Mr. Boyer, who do you have with you?
Mine now wife,
Okay, and what is her name?
Tara Boyer.
All right, this is a 2017 case, so it's an older case. Originally, there were two minor children that were the children of the marriage when you got divorced, and that was Cheyenne and Chloe. Chloe has aged out because she turned 18, correct?
Right.
Yes.
Okay. So the only child at issue is Cheyenne. She was born in 2012, and so she's about 13, correct?
Yes.
Okay. Now, when I look back at the file, what I'm showing, which I have to go to the very last court order because it controls the case, the last court order that was entered. And what I ascertained was that on January 30th of 2019, you guys received a divorce. There was a decree of divorce. There was also a parenting plan that was filed and a supplemental holiday plan. And that was the last order that was entered by the court. And it gave dad primary residential custody of the girls. And again, we're only talking about Cheyenne now. She's the only remaining minor of the parenting plan. Mom got first and third weekends, 5 p.m. Friday to 5 p.m. Sunday. Fourth weekend, Friday to Saturday. I think it was 5 to 5, but it wasn't a full weekend. And then she was awarded winter break, spring break, and summer, where then you got the same coordinating weekends. So you flipped that when she had summer custody. Then on 7/23 of 25, dad filed a motion to enforce visitation because he claimed that Cheyenne was not returned after summer visitation. She was enrolled in school in Douglas, where mom currently lives, instead of Eureka, where father lives, where he, as the primary residential parent, had her enrolled in school. Service wasn't obtained. A hearing wasn't requested. One wasn't scheduled. In the interim, a motion to modify visitation was filed by Melissa on 8/6 of 25. Again, no service, no request for a hearing date to give notice of hearing. And it was alleged there that the child did not want to return to dad and that mother could not physically force her to return. And so here we are. There was a hearing on 9/30 by notice of our court because nothing had been scheduled to get this thing up off the ground. It is a serious situation, but as I indicated, all of the procedures have to be followed. But we did want to get you together to recognize that these motions are on file. They're conflicting motions, and get this thing scheduled for a full evidentiary hearing if necessary. Additionally, mom asked that the child be heard, that the child wanted to communicate with the court. Now, please understand, there is no age in which a child can make their own decision. The court does often hear from a child or children, generally, I never want the first recourse to be testimony or involvement in the litigation. Um, but I am allowed in chambers to visit with children by agreement. If one party wants it recorded, it has to be recorded. That is not, again, my first avenue. My first avenue is generally to have a child with a school counselor, a therapist, or an advocate who the child is entrusted to, that provides information to the court, not only about the child's wishes, but what that person sees in terms of the best interest. I mean, that person reconfirms for me that the child is mature for their age, that the child is taking a position for the right reasons. Um, and
The judge explains how child input works and, more importantly, how it doesn't. There is no magic age where a child gets to decide custody, despite what parents may believe.
that is quite helpful to the court.
And Cheyenne
But
has been seeing the school counselor.
Okay. But I am, noting that for you in terms of I'm acknowledging that mom has asserted that she has an opinion about where she goes to school and who she wants to live with during the school year. So, having said that, I'm probably going to, well, I want to hear from both of you as to your position on the record under oath. And so we'll go from there. But probably the result today is going to be that I make enter a temporary order and schedule the matter for a full evidentiary hearing in person to make a final determination. The preferred route for these things is that the child should have went home under the current order, and mom, you should have filed a motion during the summer before school started to, one, give you custody of the child for the school year, to change physical custody for the school year, and to give permission to enroll her in the school instead of not following the court order, keeping the child, making him file a motion to enforce. Now I'm put in a position of, one, starting with the premise that you violated a court order, but two, having to consider yanking a child out of school that a parent has put the child in school in violation of the court order. So I have to take all of those things into consideration and try to straighten this out and provide the least amount of disruption to the child and her life, but also act in her best interest with what little information that I have. Okay, so since the motion to enforce was filed first, I'm going to have Mr. Boyer, you go first. And if you'll raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay. Now, normally, thank you, in a court proceeding, there is an attorney who asks questions and an attorney or a party that can object to questions for various legal reasons. But because you're acting as your own attorney and you're a witness because you're a party, then there isn't a lot of latitude for the court to follow evidentiary rules as it relates to testimony. So, if during the course of things, one or the other of you has an objection about particular testimony, you need to, in a orderly way, advise the court that you're objecting so that we can try to address it as best we can, given the nature of the self-represented proceeding. So, Mr. Boyer, you need to state your name and what statements you wish to give under oath with regard to Cheyenne not being returned to your care at the end of summer for the beginning of the school year.
Well, the last time I seen Cheyenne,
Okay.
Brian Boyer,
All right.
and last time I seen Cheyenne at my house was Wednesday, June 11th. Her mother come and picked her up from my house, and that was the last time I seen her. I was refused my Father's Day turning time. Your weekends. All my weekends since then, I have not got. Cheyenne got to miss out on vacation trip to Branson with us because
Okay, hang on. Ma'am, you're going to have to sit back on the couch and observe. You can't keep telling him what to say. Please, I'm sorry. Thank you. All right. Go ahead. What about your weekends?
I have not got any of my parenting time since then at
Okay.
all.
What have you done to try to facilitate getting the child or enforcing the court order?
Well, for one, when she moved to Douglas, I do not have an address where my child's at. I have no clue. All I know is she lives in Douglas, which it states in our papers too that if we move, you got to give a 30-day notice on a new address change. I haven't got one.
Okay. So what you're telling the court is you had no place to drive to.
I have no clue where my daughter is at other
Okay.
than Douglas.
And did you contact the Douglas authorities, whether it's the sheriff's office or I don't think they have a police department, frankly, but
Yes, I
try to
talked to the sheriff on July 23rd about
I'm
this.
sorry. I'm sorry. I may have interrupted you. I apologize. I couldn't hear you. Go ahead.
On July 23rd, I contacted the deputy that patrols down there, and we had a conversation on what to do. And basically, he told me to call her in as a runaway, but that goes on her permanent record, and I really didn't want that on my daughter's record.
Okay. Did he try to locate where she was living, where mom was at?
No, because don't know.
Did you does she have her own cell phone?
Yes, but it is highly monitored by her mother. Every time I try to call her, you hear it click on record.
Okay. So did you talk to your daughter on the phone after June 11th about where she was at?
Dad explains that contact with his daughter has nearly vanished. A few monitored calls, limited texts, nothing more. He testifies that Cheyenne told him repeatedly she wants to come home, misses her friends, and regrets how far this has gone.
Where her mom was living, what residence she was at?
All they've told me is she lives in Douglas. They won't give me an address.
So how many conversations on the phone did you have with your daughter?
I've had probably 3 good conversations and a few text messages, Snapchats, but other than that, my daughter really doesn't talk to me anymore.
Well, what did she say to you during those discussions about weekends with you and that kind of thing.
Well, just prior court date on the 28th of August, that evening, Cheyenne called me and she stated to me that she wanted to come back to Eureka. She misses all of her friends. She wanted to come home. And that's multiple times that I've heard that from her. I've got a text or a Snapchat from her sister where she thinks that she blew this out of proportion and went too far with all this. So Cheyenne's recognized what she's done, and I just want my daughter home.
What are you talking about? A child support enforcement action that was going on?
No.
Okay. All right. So on August 28th, she told you that she wanted to come home and go to school in Eureka.
Yeah, and missed all of her friends.
Okay. And when did school start in Eureka?
Well, it had been the 17th, I think it was. 21st. 21st, yeah.
Okay, so this was already past school having started in Eureka.
Mm-hmm.
Did you enroll her in school in Eureka?
Eureka wouldn't let me because Melissa had already enrolled her in Douglas without telling me that she's enrolling her in Douglas.
The bottom of this, by doing a full trial with an evidentiary hearing, and it has to involve a therapist and the school counselor. So you're going to have to make sure that you've got letters or them lined up to testify at the evidentiary hearing. And I will even speak to her.
I greatly appreciate
Either
that.
before or after that hearing. I'm not sure which at this point. I will even speak to her as well if I need to. But mom, she needs to be told if she doesn't go to dad's on the weekend, then she's gonna end up having to go back based on the court order that was in existence at the time that she came to stay with
Absolutely.
you. So
Okay.
that is the alternative. She needs to have a relationship with both parents. She needs time with both parents, whatever that looks like. You've been doing this weekend and switching in the summer and during breaks, and you've been doing this for a long time. So that needs to continue for dad. And if it can't, then we'll just have to go back to the way it was. And then I'll make a final decision in December based on all of the evidence that I have. But they're going to still need income information, run a child support worksheet, see what the payment should be, and have that stuff ready. Because you're going to have to owe it until it gets changed. If it gets changed. So those are just numbers, and it's pretty easy for them to figure all of that out and have that ready. Okay, so is there any questions about what we're doing?
No, ma'am.
And as I indicated, you have a right to file a contempt. And if come to find out during that proceeding, there are things that are totally untrue, like there was never any text. Mom's been hiding her out. Mom's been hiding. She was taken, all of that kind of thing. You want to pursue that. And if that is true, then that can result in even something contrary to what I have ordered today. But for now, I'm entering the temporary order that I indicated to you, and I'm scheduling this for trial. Okay?
Yes.
All right. And that will be to correspond with the school year.
I'm
Now,
working on obtaining an attorney. Is that okay?
This is a Butler County case, but you live in Greenwood, Brian, right?
Yes.
Okay. And Mom, did you used to live in Eureka?
No, ma'am. I lived in Whitewater, and then my landlord
Oh.
sold his house. I'm in Butler County still.
Okay. So
She admits keeping Cheyenne, but says she acted as a mother, not a rebel. According to her, Cheyenne begged to stay, citing drinking concerns at Dad's house.
yeah, I remember Whitewater way back when the case was filed. So all right. So that was in Butler County. That's how
Yes.
it ended up in Butler County.
Yes,
Okay.
ma'am.
All right. Now, Brian, where do you work?
Currently, I am not.
Okay. Are you on unemployment, or are you on disability, or are you just in between jobs, or what?
In between jobs, I had a bunch of health issues that I had to take care of, and it just wasn't working the way it
Okay.
should have. But I'm getting back to where I need to be.
Okay. Mom, where are you working?
I'm a quality inspector for the Department of Defense in NASA at DJ Engineering in Augusta.
Okay. So DJ engineering. So you just have a regular work week?
It's about 50 plus hours a week, yes. But yeah,
Okay.
it's very lenient. I leave at 7:15 every day and drive Cheyenne to school, and I pick her up at 3:20. And then we go to all the volleyball games. So
Trying to figure out the best time.
I get off work at 4:30 generally, but like I said, my job is very lenient anytime that is needed.
Well, I'm going to set it for all day.
Okay.
If we actually go to trial, we're going to need all day.
Yes, ma'am.
I think probably December 30th is my best day for custody trial. Now, I'm going to touch base with you before that to see if you have retained counsel or decided to get counsel,
Okay.
or if you've come to some agreement between the two of you that you decide that you don't want to have a custody trial. So you
Absolutely.
can advise me of that. So I will want to check on the status of things in November. And I think I would like to do that on Tuesday, November 25th at 4:00.
By Zoom.
That will be by Zoom.
Okay.
The trial will be in person.
Okay. And you said December 30th at what time, ma'am?
I'm sorry, 9 a.m.,
Thank
9
you.
to 5.
9 to 5. And then November 25th at 4 p.m., correct?
Yes.
Okay, thank you.
Did you get that down, Dad?
Yes, I did.
Okay. Now, the weekend should start this. Let's see. Let me look here.
She does have a volleyball tournament coming up on Saturdays. How would you like us to work that?
All right. Well, hang on here.
Okay, yes, ma'am.
Okay. So what did I say? I said the first and third weekends of October. So the 4th and the 18th. And then the 4th weekend is just Friday and Saturday.
Okay.
So actually, it's going to start the 18th.
Okay, and we have a volleyball tournament that weekend from 9 AM to 3 PM. The location has not been disclosed yet. It's to be determined because of,
Hang on.
okay,
So were you saying this weekend is the 11th?
yes, and the 18th is the tournament. We have one more week of volleyball, and then that Saturday is, I need a calendar. I can't use my phone.
Okay, so there isn't a tournament on the 11th?
Hang on, I'm double checking, ma'am. Hang on. Let me look at the calendar.
They're having weekend tournaments through the school?
Just on Saturdays, it's the tournament. Yes, ma'am. Um, so the 18th is a volleyball tournament from 9 AM to 3, and I am unknown of the location. And Brian has that schedule with him. Cheyenne took a picture and sent it to him. So it is a volleyball tournament on Saturday. So I would like to know how to work that.
Okay. Well, Brian,
And that's the last game.
Brian, I am thinking then that the weekend for just this month, because you haven't had time with her, that that you'll get the second weekend and the fourth weekend all weekend long,
Okay.
from Friday at 5 to Sunday at 5.
So the 24th and the 25th?
So the 11th and the 10th,
Oh, the 11th. So this weekend, I
the
apologize.
10th through the 12th, and the 24th through the 26th. And then in November, it will go back to 1st and 3rd, and 4th, just Friday and Saturday.
Okay.
So it'll go back to what the original plan was, just flipping it.
Okay.
And then the holiday
So-
schedule remains the same. Hang on. And the transportation in your current order says respondent shall be responsible for picking up the children at the beginning of her time, and petitioner shall be responsible for picking up the children at the end of such time.
Pickup times, transportation responsibilities, volleyball schedules, no side deals, no improvising. The judge shuts down future conflict before it starts.
Except for the fourth weekend of each month, in which case the party receiving parenting time the first half of said weekend shall be solely responsible for transporting the children. So I assume you still have copies of your court orders.
I do.
So all you have to do is flip that.
So he needs to come to my house to pick her up on Friday.
Yes. And
Okay.
then you,
We'll go to his house and pick her up on Sunday.
yes.
Correct. See.
All right. Can you guys live with this for now as the court order and follow it without any more intervention from authorities? Okay.
Yes, ma'am.
Do not make plans for the weekend or have her make plans with her friends or anything else.
Absolutely.
Because she's not in high school.
No, ma'am.
Her activities should be extracurricular and affiliated with the school, and everything else comes secondary to her family time with her family, including her father.
Yes.
All right. Dad, I would strongly suggest that you either have witnesses that say you don't consume alcohol very often or at all, and that you don't have an alcohol abuse problem through a drug or alcohol evaluation, or or if you can disprove all of it, you're free to do that. If you do have an issue with depression or drinking, you've fallen on some hard times with work, hey, just get into therapy or treatment. And only you can decide, and only you and your wife know what's really going on. And I will leave it at that. As I stated, I am not prejudging anything, but I am suggesting if there is a problem, that it needs to be acknowledged and needs to be addressed. And I'm hopeful that just by prohibiting it, and if you don't have a problem, that it just simply won't be an issue. So I don't know, but I want to see things get back, or us get you back on a good path, both of you. So anything else that needs to come before the court today?
No,
I
ma'am.
don't think so.
I generally, if they're attorneys, I have them journalize whatever I order based on their motions. So that would be Melissa, you filed a motion. It's been partially granted.
And I will get that served correctly to him.
And I would have you do an order that summarizes what occurred. But I doubt that you probably will get that put together because our success rate with that with self-represented folks is not very good. So I will try to put something together and get it filed. I am going to be out of town for a few days, and we have a holiday on Monday where the court's completely closed. But I expect that you all will follow the oral, verbal orders that I made today until all of this can get on file, which may be the end of next week. Okay?
Yes.
Sounds
All
good.
right. If there's nothing further, we are adjourned.
The judge reminds both parents that custody can still shift in either direction, depending on what's proven. This isn't over. It's just paused under court supervision. And with that, the gavel metaphorically drops. A courtroom trying to restore order, a child caught in the middle, and two parents standing at a crossroads. Follow the law or lose control entirely.